the statistics on the abuse under the matrimonial laws under 498A, the marriage takes place on 3/5/2023. 16-month delay in filing the complaint before the police. Both are doctors, highly educated. Physical abuse, mental abuse, violence is attributed against the husband, the mother, the brother, the uncle, and all family members, while before that in no paragraph do you find any allegations against any of them. Then there are dowry claims which have been made saying 2 crore in cash was demanded, property was demanded in Hyderabad, and not 1.5 kg of gold. The allegations is that the husband takes drugs, he is an alcoholic, he's had extra-marital affair because of which they separated. Now 4 months into the marriage fails because he's having some extra-marital affair is their allegation.
The members of the family, yes, I'm going to quash.
Yes.
I'll subject to what
Yes.
you would say. That's been the
Yes.
norm.
Yes.
With, husband, yes, come after filing of charge.
Yes. The husband and his 4 relatives are before this court.
304B, na?
No. 498A and 3 and 4 the DPR. 498A.
They
Mentioned on the previous day, A3, who's the brother of the husband, has secured admission.
Employment.
So
Yes.
Lord, my entire endeavor will be to show to your lordships that the case is squarely covered under ground 7 of Bhajanlal, which is where proceedings are instituted with a view to wreak vengeance and personal grudges. Lord, my case is not that the wife has instituted this and this entire case is a case of over-implication. Because if I say if it is an over-implication, that means the husband has been rightly implicated while the other 4 have been wrongly implicated. My case before your lordship is going to be that it's a case of exaggerated versions of petty quibbles insofar as the husband is concerned, and the others in any way unwarranted implication.
There's an interim order, right?
There's an interim order
Yes,
already
yes.
operating, even against the husband. Sound not?
Even against the husband.
There's some detailed research that we have done which we want to place with your lordship. Due to bring some solution to the larger menace of false dowry harassment claims. But before that, since I brought my case under ground 7, before I take your lordships through the ingredients and the allegations in the complaint, I only want to point out how the test of review, the standard of review and the scope of review at the crime stage has changed from Bhajanlal to Achin Gupta. But the test in Bhajanlal was take all the ingredients on the face of it, believe it to be true, and yet if the allegations do not make out an offence, then only quash. Now I'm not seeing the statistics on the abuse under the matrimonial laws under 498A and the line of judgments which have pointed out how marriage laws 498A have been abused. Achin Gupta now takes a full turn where it says, citing ground 7, even if allegations disclose ingredients, which in my case it does not, even if it does, still the court will have to exercise a greater standard of scrutiny and ask for corroborative evidence even at the crime stage. Now, Lord, before I take your lordships to the allegations, it's very important to note the difference in the scope of review. Bhajanlal, take it as it is, take it to be true. But under Achin Gupta now, it is not enough for your lordships to take a hands-off approach minute the allegations are there in the complaint. Because allegations, what the courts have said, Justice Pardiwala has said, many a times lawyers define allegations in such a way so as to suit the ingredients. So looking at statistics, now the courts are saying, do not simply take a hands-off approach, ask more probing questions, look for corroborative evidence. And when your lordship were to look at the allegations in this complaint, not a single speck of not a single speck of credible contemporaneous evidence that is attached along with the complaint. Now, Lord, there are 5 or 6 preliminary points that I want to make. Just please note 2 dates, Lord. The marriage takes place on 3/5/2023. The lordship will only note this date, not marriage takes place on 3/5/2023. The husband and wife have resided together in a shared cohabitation only for 4 months. Complaint is lodged in February of 2025 by the wife. There is a 16-month delay in filing the complaint before the police. No preliminary inquiry initiated. Straight away, the police go ahead and register an FIR. And it's very important to note because there are the 4 other accused as well.
Yes.
The husband and wife at no point of time have resided together with the in-laws or with the aunt and uncle. At no point of time, both are doctors, highly educated. The wife is a PG graduate in radiology, husband is a MCH in urology. Not at no point did they stay along with the parents of the husband or the in-laws of the wife.
Hmm.
7-page, 26-para lawyer drafted complaint,
Hmm.
suitably designed to bring allegations within the ingredients of the offence.
Hmm.
And if the lordships were only to see para 26 of the complaint plot, the lordships will find at page 33 of the petition. Now, this symbolizes the vexatious, omnibus, and generic allegations. because the lordship will
Others
see-
you forget.
No,
Now,
I come
concentrate
only
on the husband.
But I just want to see how the complaint in para 26 squarely, Lord, is omnibus generic, because it says, and this runs writ large through the entire complaint. Physical abuse, mental abuse, violence is attributed against the husband, the mother, the brother, the uncle, and all family members, while before that in no paragraph do you find any allegations against any of them. Now, Lord, let's come straight to the husband, Lord. Now, there I have seen, Lord, there are, if I take all the allegations against me, they can be brought under 5 or 6 heads, Lord. One is emotional abuse, physical abuse. Then there are dowry claims which have been made, saying 2 crore in cash was demanded, property was demanded in Hyderabad, and not 1.5 kg of gold. Point number 1, which your lordship will note, they have pleaded in their complaint that the father of the wife has met the demand to the extent of 1.25 lakh in cash. Just please note this. The father has said of the wife that he has given, in fact, 1.25 in cash. Now, Lord, the other allegations is that the husband takes drugs, he is an alcoholic, he's had extra-marital affair because of which they separated. Now, 4 months into the marriage fails because he's having some extra-marital affair is their allegation. Assume it to be true. It took you 16 months as a doctor, no medical certificate produced. Not, there are allegations that there were bruises on the lips. Now, please come to not that allegation. This is the only physical abuse allegation which is supported with evidence. Not. The lordship will come to their statement of objections, and not they've produced the pictures to show that this is physical abuse. Now, Lord, your lordship will have to decide whether this is physical abuse.
No. Why will I decide?
Yes.
Yes.
Your lordship will only come to page 30 of their statement of objections.
No, others I will straight away quash. I will not listen to them. But as far as the husband is concerned, all this.
Yes, then Lord, let me just show your lordship what the allegations are, then your lordship may decide. Please come to page 31.
Of the objections?
Yes, of the objections. 31.
You know.
This is the physical abuse. 14/5/2023, bruise on my lips. Now, Lord, proceedings are being live streamed. I don't want to say this is at the honeymoon or Bali.
All right. Yes.
This is the only evidence which is corroborative to show that there was physical abuse during honeymoon in Bali. These are the 2 pictures that have been produced. Now, please come to 33. 33, page 33.
That's why it took 16 months to complain.
It took 16 months. And Lord, please see this. If you are abused, there is cruelty, logically not any rational person will first immediately want to separate 5 divorce claims separate out.
That rationale now you can't draw. Husband difficult. Others straight away. Whatever they may argue.
Not, let me say this. In Achin Gupta, let me share. Your lordships have generally taken a view that husband must not receive the immunity which other receive. But in Achin Gupta, I only want to tell your lordship.
Yes, Sachin Gupta, Abhishek.
Yes, I'll tell you what
all that, yes.
The entire reasoning was this. Please see the reasoning, appreciate the reasoning. In the FIR, it was the husband and relatives. In the charge sheet, they dropped the relatives, only husband remains.
Correct.
Challenges High Court does not quash.
Correct.
And it is in that context that Justice Pardewala came down very heavily, saying if there were
Even
2 allegations,
yes.
if you have to take the FIR blindly, then why did the police drop the other 4 in the charge sheet? And they quash it against the husband.
Correct.
They have to conduct a merit-based review, even if it is on the.
No, see, there is no material today except the complaint that is filed of the prosecution before me.
Yes.
It is stayed immediately.
Yes. Now,
so
the question is, what is the evidence that the police can recover?
No, can recover, we don't know. I can't telescope my imagination there. Now, the members of the family, yes, I'm going to quash.
Yes.
I'll subject to what
yes.
you would say. That's been the
yes.
norm.
Yes.
Husband, yes, come after filing of charge sheet.
Yes.
If charge sheet is filed.
Then, if your lordships are going to direct investigation against the husband, my submission is going to be this. since they have made a claim, there are two acts which have not been noticed by this court, which is the Dowry Prohibition Act under Section 8B and the rules that are framed thereunder. 4 authorities also have produced. Please come to Neera Singh, Lord, which is a judgment of the
Allahabad High Court.
Delhi High Court.
Delhi.
And Neera Singh is Allahabad High Court. Please come to Neera Singh at page 69. Wild allegations of 3 crores, 5 crores are made very regularly. Please see what the Delhi High Court has said. Para 3, Lord. Permit me to read para 3 and para 4. A perusal, page 69. Page 69.
I'm there.
A perusal of the complaint would show that as per allegations, dowry demand was made even before marriage, and an AC was demanded from her father and her in-laws, and her father had assured that AC would be given at the time of marriage. She told her father, "You have given car and AC at the demand. What will happen if they demand a flat tomorrow?" Despite her this conversation with the father, and despite her knowing that dowry demand had already been made, she married in the same family, irrespective of the fact that she was well educated and was an engineer and her brother was in police. In fact, these kind of allegations made after breakdown show the mentality. I consider where these kinds of allegations are made, the police should simultaneously register the case under the Dowry Prohibition Act against the parents of the complainant as well, who married their daughter despite demand of dowry. Section 3 of the Act prohibits giving and taking of dowry. If a woman of grown-up age and well-educated gets married to a person despite dowry demand, she and her family becomes accomplice in the crime under the Dowry Prohibition Act. Now please come to para 5. Metropolitan magistrate should take cognizance of the offence under the Act in respect of the offence of giving dowry. Whenever allegations are made that dowry was given as a consideration of marriage after demand, court should also insist upon compliance with the rules framed under the Act, and if the rules are not complied with, an adverse inference should be drawn. If huge cash amounts are alleged to be given at the time of marriage, which are not accounted anywhere, such cash transactions should be brought to the notice of the Income Tax Department by the court, so that source of income is verified and the person is brought to law. It is only because the courts are not insisting upon compliance with the relevant provisions of law while entertaining such complaints, and action is taken merely on the statement of the complaint without any verification, that a large number of false complaints are pouring in. Therefore, Lord, this is what the Delhi High Court has said. If you are going to make allegation that you have given 2 crore and you have met that demand, now even under the Prevention of Corruption Act,
giving Corruption Act, giving and taking, definitely.
No, even under the PC.
PC Act, definitely giving and taking, both are punishable. I have myself written.
Yes.
That doesn't, you can't paraphrase that to dowry in the Indian.
I'm not paraphrasing. The section itself says. No. In fact, I just want to show Lordship the Allahabad High Court judgment itself, which also examines the entire provisions of the Act, the dowry prohibition and the rules framed thereunder.
No, but this Allahabad I have seen. Next, Justice Vinod Chavan.
Yes, Ankit Singh. Just come to the guidelines, Lord. I just want to show Lordship what the guidelines are. There is a dowry prohibition officer constituted under the Dowry Prohibition Act.
Nobody will complain in that. Nobody will complain. No. They want their daughters to be married.
Correct.
They will complain.
But instead of complaining to the police, what the law requires is that you
they don't complain to the police immediately.
Yes.
They complain to the police when the relationship turns sour.
I am saying
that doesn't mean relationship turning sour. I had given dowry 2 years back, and they go to the dowry prohibition officer and complain. No.
At the end of the day, the allegation is still claim and meeting of dowry claims. I am not saying that it is because of 16 months delay you don't file it. I am only saying it has to go before the Dowry Prohibition Officer.
Let's see. We'll leave all options open to you to come back after filing of the final report.
Yes, I'll only.
Husband, I am not going.
Yes, I'll only tell you.
Whether it is 16 months, whether it is a bruise happened anywhere, I am not going to enter into all that, because it is a 482 petition and we are still at the nascent stage where we are only looking at the complaint.
Yes.
Complaint, it's about 16 pages, whether it is lawyer drafted or the petition, the complainant drafted is not the stage at which I do it. Other members of the family, yes.
Fair enough. Then let me say this.
Subject to what Arun would say.
These 498, 3 and 4 charge sheets on a daily basis.
That we'll see. That's why.
In that charge sheet, there will be self-serving statements of victims.
So at this stage of crime, very rarely, exceptional cases, I have quashed the proceedings against the husband.
Which is why I began with the scope of review, that now it is incumbent on the court to ask more probing questions at that stage. Is what Achin Gupta said.
Probing questions will only be if there is some investigation done. Nothing is done in this. It's still nascent stage.
16 months later, what kind of investigation?
That's what we don't know. We don't know.
Only allegation is I'm an alcoholic, I'm a drug consumer, I've abused you.
No, we don't know. See, statements are not recorded still. Nothing is done. We'll see later. Yes, Arun. Other bit padi. ಆಯ್ತು.
The husband and family hail from Hyderabad.
ಹ್ಮ್.
The second responsibility hails from Karnataka.
ಹ್ಮ್.
The practice not both are doctors. Arranged marriage. So it is a serious.
How is that? How it is arranged? No problem. Don't go into details. Yes. Hmm.
Specific allegations of the mother-in-law demanding. I'm sorry, the brother-in-law specific allegation. He asked for a watch was given. But the mother, I have stayed in Hyderabad at the house where I was assaulted by the mother-in-law and husband.
My learned friend is
ಅದಕ್ಕೆ 16 months ತಗೊಬೇಕಾಗಿರ್ಲಿಲ್ಲ.
So, after the Kachmadas were there, there was obviously an effort to reconcile.
I am not on that. See, why draw other members of the family? Law is goaded against you in that. This husband, yes. Husband also there is law, I'm not saying. But the facts obtaining in each case. So we'll permit the husband to come back after the final report if there is a final report. Others I'm not doing.
My only point will be that in respect of these allegations that my family is demanded and these allegations were met, how is it that I prove the negative? If somebody says I have demanded 2 crore, how can I prove the negative? They having said that they have met their demand, the
We'll see.
burden is on them.
We'll
The
see.
Lordship will only direct the police to investigate that as well.
Police will investigate everything, every angle, the husband.
The Lordship will
Every
record my
angle,
observation
yes.
and in that context, Lord, they should.
Every angle, yes. Even the dowry angle, everything they will see.
Because 16 months delay.
No, that we'll see. See, well, I'll tell you, not in this case or other case. Women, when they are harassed by the members of the family or the husband, they don't immediately jump to the police station. They always think of a reconciliation. Only when she is driven to the wall by all of them, or the husband, yes, files a petition for divorce, then she feels, yes, I have undergone all this misery, I've endured everything. Even then it ends up in a divorce. So then registers a 498A. Not in all cases. Sometimes frivolous, sometimes, but you can't paint everything with the same brush.
I fully appreciate.
So when women is driven to the wall only she will go. Otherwise reconciliation definitely will go on as a process. Because endurance is known to them no more than us. Yes.
It should not happen that in the attempt to save the harassed men, that genuine complaints are not weeded out.
No, that's so many cases I stay for the husband, quash it on the husband, but there should be some material. Andre charge sheet ಏನಾದ್ರು ಇದ್ರೆ ಖಂಡಿತವಾಗ್ಲೂ ಮಾಡಬಹುದು. Here it is a stage of investigation, will not interfere with that.
Yes, then let be a timeline at least on investigation.
That we'll see. Yes,
At least
this
the timeline
wherever you want to travel, accused number 3 or whatever, watch.
Once it's
That
quashed,
is quashed, that's over. Yes.
insofar as the husband is
Husband,
concerned,
I am not.
timeline at least for investigation. He's a doctor, not
That we'll see. Radiologist,
urologist.
neurologist.
I'm a radiologist.
You are a radiologist. You are a neurologist.
Urologist.
Urologist. You are okay. Yes, fine. Right, we'll dispose it in that way. Operative person Markuli.
Like a lordship's judgment, no, Rajiv Gowda. When an FIR is there with allegations, it's for the police to.
Not on others.
Then should-
Other I will give you. Insofar as 498, I will give you everything if you want. Against others. Husband, I am not. When they did not even reside with you. Yellow.
Hyderabad, I was staying in Hyderabad with them not immediately after marriage.
In her complaint only, she says we never stayed there. We have stayed only for a few days just after marriage as part of rituals. But after that, we rented a flat in Bangalore.
I'll leave it to my
and
lord.
stayed in
I do not
tell
want
you.
to. I do not want to live.
But they don't get into nitty-gritty of
I
that.
will not.
Because now ilidde, avagidde, 2 hours idde, 3 hours idde. Don't do all that. Yes.
Their purpose is to coerce a settlement.
I will see. Settlement. Adu madಕೊಳ್ಳಿ. Both of you are doctors, you should settle it. What is this? Yes. The petition is allowed in part. The proceedings insofar as the accused number 1 husband is concerned stand sustained. Investigation shall ensue and the investigating officer shall see to that the investigation is completed expeditiously. The petition insofar as the other accused are concerned is allowed. The crime in crime number so and so, accused 2 to
5.
2 to 5 stands obliterated. Yes.
So great.
सिर्फ 4 महीने की शादी और आरोप इतने बड़े कि 2 करोड़ रुपए, 1.5 केजी सोना और एक्स्ट्रा मैरिटल अफेयर तक बात पहुंच गई। कर्नाटका हाईकोर्ट की इस केस प्रोसीडिंग में माननीय जज साहब को भी गहराई से सोचने पर मजबूर कर दिया। दरअसल दोनों पति पत्नी पेशे से डॉक्टर थे। 2023 में उनकी शादी हुई, लेकिन सिर्फ 4 महीने साथ रहने के बाद ही दोनों में अनबन शुरू हो गई और दोनों अलग हो गए। 2025 में पत्नी ने अपने पति और उसके पूरे घर परिवार वालों पर 498 का झूठा मुकदमा दर्ज करा दिया। उसने आरोप लगाया कि उसे मेंटल और फिजिकल प्रताड़ना झेलना पड़ा है। इतना ही नहीं, उसने अपने पति और घर वालों पर 2 करोड़ रुपए, हैदराबाद में प्रॉपर्टी और 1.5 केजी गोल्ड की डिमांड का भी जिक्र किया। साथ ही पति पर अफेयर और ड्रग एडिक्शन जैसे गंभीर आरोप भी लगाए। माननीय न्यायाधीश एम नागा प्रसन्ना ने हर आरोप को एविडेंस के साथ परखा। माननीय न्यायालय ने देखा कि फैमिली मेंबर्स के खिलाफ कोई डायरेक्ट और ठोस प्रूफ नहीं है। सिर्फ एलिगेशंस के बेसिस पर उन्हें केस में फंसाना और ज्यादा सफर कराना ठीक नहीं है। इसी वजह से माननीय न्यायालय ने पति के परिवार के खिलाफ चल रहे सारे चार्जेस को तुरंत क्वेश कर दिया। लेकिन पति के मामले में माननीय न्यायालय ने अलग अप्रोच ली। माननीय न्यायाधीश ने कहा कि आरोप बहुत ही गंभीर हैं और अभी जांच पूरी तरह से हुई नहीं है, इसलिए बिना प्रॉपर जांच पड़ताल के उसे क्लीन चिट देना सही नहीं होगा। इसी वजह से माननीय न्यायाधीश ने पति को अभी तुरंत रिलीफ देने से मना कर दिया। ये फैसला एक इम्पोर्टेंट मैसेज देता है कि कानून का दुरुपयोग रोकना भी उतना ही जरूरी है जितना किसी दोषी को न्याय देना। न्यायालय हर केस में सिर्फ एक चीज देखता है और वो है सबूत। बिना मजबूत सबूत के किसी को भी दोषी नहीं माना जा सकता है। सच और सबूत के बीच का फर्क ही कोर्ट का असली फैसला तय करता है। ऐसे ही कोर्ट केस एनालिसिस और लीगल अवेयरनेस वीडियो के लिए वीडियो को लाइक और चैनल को सब्सक्राइब करना ना भूलें। धन्यवाद।